Student conduct as we know it today rose from the student protests and court decisions of the 1960s. The St. John Dixon versus the State of Alabama Board of Education decision was possibly the most notable, as it prompted advances in student rights and professionalized student conduct administration. A group of students from Alabama State College in Montgomery, Alabama, participated in an orderly, peaceful sit-in at their local county courthouse lunch counter. The students were not arrested, but instead all were punished and 9 expelled from school at the direction of the state's governor and the decision of the state board. The students filed the St. John Dixon versus the State of Alabama Board of Education 1961 lawsuit that, when decided for the expelled protesters, established that students had rights while at college. The administration of student conduct on college campuses today began with and continues to be shaped by their story. Here it is in their own words.
Inspired by the Montgomery bus boycott, those hundreds of students throughout the South, as Mr. Gray says, challenged the operation and maintenance of white-only lunch counters, libraries, bus station waiting rooms, segregated theaters, and all other places of public accommodation. On too many occasions, those students who participated in these peaceful demonstrations for racial equality were harassed and beaten by angry whites and then subjected to criminal charges that they, not those who had assaulted them, were guilty of Southern law called breach of peace.
I was strongly motivated by the history that had been established in Montgomery, Alabama. And I feel honored to be a part of something that I thought was extremely important in history because of the bus boycott that had taken place previous. When I arrived at Alabama State, the bus boycott was in process. And I received, I believe for me, my training and part of my inspiration to get involved in the sit-in movement. I believe that it was just as Solomon Say Sr. said to us a long time, that it was just important to be at a particular place in history at a particular time. But one of the things that was important is to be able to take on your responsibility as others has taken on their responsibility. I also felt like it was important to my parents and to my family to continue the progress that was taking place in the state of Alabama, meaning that if the buses now could roll and we could ride and sit in a place that we want, that there was some responsibility in making sure that where we eat was also open and acceptable. We learned, at least we thought we would have a better case if we went to the courthouse as opposed to a private run institution. And I was challenged and I was excited about that because I felt that part of the courthouse belonged to me. So I had a right to be there and to demonstrate. I had been taught that if I happened to be in a situation and find something that was wrong, that I had a responsibility to make it right. I had no idea, though, that this would cause the rippling effect that happened. It was a good situation. We were trying to right wrong, but at the same time, we created problems for our communities, problems for our families. But in doing that, we were able to open doors that were closed.
Eventually, the students and their attorney, Fred Gray, the attorney who represented Dr. Martin Luther King Jr. and the others in the Montgomery bus boycott case, sued the school for readmittance. The initial decision and processes used to remove the students were upheld at the district court hearing before Judge Frank M. Johnson. The case law at the time considered the actions of the governor and the discipline process legally defensible and appropriate. However, the Fifth Circuit Court of Appeals in St. John Dixon versus the State of Alabama Board of Education, 1961, found in favor of the students. This case ended the in loco parentis student-institution relationship and extended rights, specifically due process rights in this instance. The lesson to be learned from their story is that best practice in student conduct honors the sacrifice these students and administrators made so many years ago. Conduct decisions and the manner in which hearing boards reach those decisions are an educational process with legal and ethical dimensions. But what does that really mean?